Hey guys, this is Ben from Cut Law. In this video, I'm going to talk about indemnity clauses. What is an indemnity clause? Well, an indemnity clause, to put it very simply, means I don't care who caused me loss. I don't care whether it's your fault, somebody else's fault. As long as I lose money, you have to compensate me. That's why an indemnity clause, that's how it works essentially. Let me show you what a typical standard indemnity clause looks like over here. Why do people put indemnity clauses? Because, as I said before, they don't need to show a link between losing money, the loss, and someone else's breach. Okay? Because without an indemnity clause, if you go to the courts to sue, you are suing for damages. Okay? You have to prove that the breach caused the loss. There is causation. The breach caused the loss. There's also issue of remoteness. What is remoteness? Remoteness means whether the loss is so far-fetched, so unforeseeable that it could not have been foreseen by the parties. If the loss is too remote, the court will not grant you damages. Okay, then there's the third issue called mitigation of loss. Okay, when there's a breach, you're supposed to take steps to prevent losing further. Okay, now an indemnity clause will avoid all these hurdles. Because if you sue in court, you are suing for damages. Whereas if there's an indemnity clause, they don't need to prove anything. They don't need to prove that your breach caused the loss. It is actually a debt, okay? D-E-B-T is a debt due. You're not getting damages. You're being compensated fully. And also, it is common for indemnity clauses to state that to also include legal fees as well on a full indemnity basis. It means any money you spend on the lawyer, you get compensated fully for it. So I always tell my clients, never ever give an indemnity clause unless they are in a very weak position. And even if they're in a very weak position, I always tell them, make sure the indemnity clause is very specifically drafted, covering specific scenarios, circumstances, situations that they think could arise, okay? Because you don't want a huge white blanket, very broad indemnity cap covering everything under the sun, and anything happens, the indemnity clause is activated and you have to pay the other party. So without any question, whether it is fault or no fault, okay? Since I've talked about the broad indemnity clause, I want to go to a recent court decision. I think it's 2018. It's called the CIFG case. In that case, the Court of Appeal held that the indemnity clause was too broad. They also found that the indemnity clause was added at the last minute as an afterthought to the agreements, after the term sheets were signed, okay? And they found that such a broad indemnity clause did not cover the transactions contemplated because the agreements already allocated the risk to each party. So to have an overly broad indemnity clause would be absurd in the words of the court. So it is very important. Firstly, you should not give an indemnity. Even if you have to give an indemnity, try to limit it to be very specific. Okay, that's all I have to say about indemnity clauses. Now, if you like this video, click subscribe, click like. Thanks a lot for watching.